Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. As you can see, I'm not in my regular location. I'm coming to you from an undisclosed location, but I wanted to show you the view because it's pretty freaking awesome. And when I move into frame, then the camera's going to focus on me and then you won't get to see the ocean. So for those of you who are living someplace where it's really, really cold and you're shoveling today, enjoy. I don't think it's going to get sunny today, but you know what? I'm here, and that's more important. A little bit of sun doesn't really matter. It doesn't really matter. See, now it'll focus on me, and you won't be able to enjoy the ocean view. But let me tell you something. When I crack open this door, it is so loud. It is so loud. Good morning. All right, so we have a hearing on Ashley Benefield today. I'm in a hotel somewhere. That's not my usual spot, and so I don't know if the internet is going to be as good as I want it to be for me to be able to stream the actual hearing live, but we're going to give it a go because that's what we do. We give it a go. We try. Hi, what's everyone? Cold? Ashley Benefield has a hearing today to be let out on bond pending her appeal. We've sat through an entire trial. We've sat through the evil stepsisters. We have seen Judge White in action, and my guess, I had to give you my best educated guess. He's going to say, hell to the gnaw. But I did speak with Neil Taylor the other day. He reached out to me, Ashley's attorney, and he wanted to thank you, all of you, for being so supportive of Ashley, and thank me for my coverage, because I guess I'm the only one who seems to be covering this case with any sensitivity. If you know someone else who is, please let me know. I would like to have a comrade, somebody who gets it. That said, there's not going to be any tolerance in the chat today for any hatred and vitriol. So if you cannot control yourself and you feel that you need to be hateful, spiteful, vitriolic, and victim blaming, then please go to Law and Crime and watch the coverage there, because that's where it's at. You can go there. You can try and survive in the chat. Let me know, mods, Brittany or Scott, if you're here and the volume is off or the sound is off, or if I'm fading in and out, or if it lags when I stream, let me know. So I spoke with Neil Taylor. He reached out to me and we had a video call. And I asked him how Ashley is doing. He said she's doing surprisingly well. That she is, luckily she's been held in the Manatee County Jail all this time since her sentencing. And we'll see what happens on this motion today. But he just wanted to thank you all for your support. And I asked about Emerson. He said that she is also doing really well. She's really smart. She turned 7 recently. And he said that he's one of the smartest kids and nicest kids that he's ever met. And his, you could just see him tearing up. He's a really nice guy. He's a really great attorney. And I think she's got a good chance on appeal, but appeals cost money. It's going to cost $100,000 for an appeal. And he also said, I asked if there was any way that you guys could help, if you guys could send letters to Ashley. I'm going to put Neil Taylor's address below. He said if anybody would like to write her a letter, she would love that. And you can send them to his office address and he will make sure that she gets them. So I'll put that in the show notes later. But let's take a look, first of all, at the motion papers quickly because this motion is the hearing's supposed to start at 8:30 Eastern, and it is now 8:07. And we know that Judge White starts on time. Boy, it's humid here. Can you tell? Can you tell this mess that's happening? And I had to shut off the air conditioning because it's so loud. I feel like I'm sitting in Norfolk Superior courtroom, and they turned off the air conditioning, and now I'm gonna sweat. Okay. Yeah, we're allowed to disagree, but we're not allowed to be hateful. So that's great. No, and if you can relay your opinion respectfully, that's fine. What happens here is there are a lot of trolls out, not just from this case, but also from the Karen Reed case that just want to come in here and start trouble. And if that's the way people behave, then they're timed out, and my mods have no tolerance for it. So there's that. I have the best mods on YouTube, so there's that. All right, here you go. This is a motion for release on bond pending appeal and request for a hearing. Just to go over a little bit of the summary of facts, Ms. Benefield was charged by information with second-degree murder with a firearm in relation to the death of her estranged husband, Doug Benefield. Following a jury trial, Ms. Benefield was found guilty of the lesser-included offense of manslaughter with a firearm on July 30th of 2024. On December 3rd, 2024, this court sentenced Ms. Benefield to 20 years in prison, followed by 10 years of probation. Ms. Benefield's Criminal Punishment Code, CPC, score sheet reflected a total of 194 sentence points and a lowest permissible sentence of 124.5 months or 10.375 years in prison. And that is breaking for a second to tell you, those are the guidelines in Florida, okay? Those are the guidelines, like them or not. She does meet the guidelines and the qualifications for a lesser sentence. And look, we did that here. We watched. Well, we didn't get to watch the stand your ground hearing yesterday on the dentist from Florida who beat the bejesus and almost killed a man with a golf club that he didn't even know, who was walking on the cart path at a country club. And his stand your ground hearing was yesterday. Somebody sent me an article on that, but I couldn't, like, it wouldn't load. And I don't know if he's allowed to use stand your ground. And I don't know if there was even a decision on it yesterday or if there's going to be a written decision. Do you guys know that? Anybody know? Dr. Orabig. So there's that. Look, stand your ground was made for victims of DV. I think that's why it was enacted. And there's a lot of hateful people out there who just, I don't know, can't get a grip, or they've never had to deal with it, or they don't know anybody who has been a victim or a survivor of DV. And so they say, oh, well, he never actually beat her. He never beat her. Why should she be afraid? And I just don't have any tolerance for that sort of there's not even a word that I can think. Understanding. People who don't understand the cycle of domestic violence don't understand the cycle of domestic violence. And they don't understand that just because someone's never beat you before, that doesn't mean that they're using coercive control and that they may actually kill you when they've shown you that they are capable of rendering a dog unconscious by punching him in the face, shooting a gun in the ceiling to scare you, punching holes in walls, throwing cats downstairs, and various other things like stalking, putting a tracker on your car. So how many times do you need to allow yourself to be beaten before you're allowed to use justifiable force or deadly force? This man likely could have killed her with his bare hands. And I'm going to point out again, for those of you who don't know, he was also known to carry a gun at all times. So there's that. But again, I'm not here to lecture you. I'm here to explain the law to you. Under the guidelines and the law of Florida, she does meet the guidelines for a lesser sentence. And when we watched the sentencing, everything that Judge White said up until he imposed the 20 years led me to believe, and many of you in the chat to believe, that he was going to downward depart. But alas, he did not. And so here we are. Back to the document. Rule 6.91A provides that all persons who have been adjudicated guilty of the commission of any offense, not capital, may be released pending review of the conviction at the discretion of either the trial or appellate court, applying the principles enunciated in Young Hands. That's the controlling case here. Youngans v. State. It's a Florida case from 1956. Although a trial court's decision to grant or deny a supersedious bond is discretionary, it must be exercised within the guidelines established by case law and adopted by court rule. It is insufficient for a trial court to merely make conclusory findings unsupported by the record or give a mere verbatim recital of the considerations of Youngans. A convicted defendant should normally be admitted to bail pending appeal if appeal is taken in good faith on grounds not frivolous but fairly debatable. The terms good faith on grounds fairly debatable and not frivolous doesn't require a prognostication of the ultimate outcome of the appeal. Good faith does not mean that there is probable cause to believe that the judgment will be reversed, but simply that the appeal is not vexatious and the defendant has assigned errors that are open to debate and about which reasonable questions exist. The good faith requirement is a relatively low threshold. Ms. Benefield's appeal is taken in good faith on grounds which are not frivolous but fairly debatable. Ms. Benefield has already identified numerous grounds for appeal in her motion for a new trial, defendant's memorandum of law in support of a new trial based on juror misconduct, and sentencing memorandum. These issues include, but are not limited to, multiple instances of prosecutorial misconduct during closing argument, as well as juror misconduct by juror 15. Okay, remember both of those things were determined in the last motion, which I think was heard the hearing before her sentencing, but now I can't recall. And as you know, one of the jurors did admit to lying on their jury questionnaire and saying that they had never been a victim or a perpetrator of DV when it was brought out that that woman had been a victim and a perpetrator of DV. In my opinion, that was enough for a new trial. The judge didn't think so, and he did not grant a new trial. I find that to be highly prejudicial if you have jurors that are going to lie on their questionnaire, because voir dire is one of the most important parts of a trial. When you're a trial lawyer, picking the jury is of utmost importance, obviously. And I do not think that that woman would have been selected. That's my opinion. You don't have to agree with it. And also, remember, we talked about the closing arguments by the evil stepsisters. And I'm going to continue to call them the evil stepsisters because if you've ever watched Cinderella, first of all, they kind of look like the characters in that movie. And also their behavior was so egregious during the course of this trial. I've never seen two prosecutors behave so dismissively and rudely, without even a basic modicum of respect for a defendant that they were questioning, especially in a highly charged case where the defendant is alleging that she's a victim of DV. She had a restraining order against him in North Carolina. She tried to get the law enforcement in Florida to enforce it. They wouldn't enforce it. And if you guys watch that trial with me, you remember that officer who came and testified about how she was such a scutch and she was a pain in the neck, and she kept calling me and calling me. What was I going to do about it? And then we find out during trial that Doug Benefield was trying to rent the house right behind her when there was an active restraining order against him. So she tried to do everything, in my opinion, within the bounds of the law. And that day was a final straw. He might have killed her. She might have been a Katie McLean. For those of you who are following the Dr. Harry Turk case with me in Massachusetts. After a history of DV, one night, Harry got angry and strangled his wife and dumped her in a swamp and confessed to it and told the cops where the body was. This is in Massachusetts. This is another reason why many victims and survivors hesitate to come forward, because they see results like this and they're like, well, what am I going to do about it? Why would I go to trial? Why am I going to try and even report if nobody's going to believe me? And she could have been the one in the ground. And he could be on trial right now. And that's that. Here are the factors that the Florida Supreme Court has decided must be considered when a defendant asks for post-trial bond pending an appeal, and that is number one, the habits of the defendant as to respect for the law, the defendant's local attachment to the community by way of family ties, business, or investments, the severity of the punishment imposed, and any other circumstances relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. The Youngins factors also weigh heavily in favor of bond pending appeal. First, Ms. Benefield's habits show her respect for the law. Ms. Benefield has no prior felony convictions. Ms. Benefield has been released on a $100,000 bond in pretrial supervision without incident since November 20th of 2020. So remember, she was out on bond for the entire time until the trial. Ms. Benefield's pretrial release conditions included electronic monitoring, curfew, surrender of her passport, prohibition of the possession of firearms or weapons, no contact with state witnesses, and a child safety plan. There have been no allegations of violation of her supervised release. Ms. Benefield has likewise appeared for all court hearings when her presence was required. Second, Ms. Benefield has local attachments to the community. She's lived in Manatee County and will be living with her mother and her 6-year-old child, Emerson is now 7, in the local community upon her release. Ms. Benefield also has provided this court with numerous letters of support, both from loved ones and from survivors of DV. And many of those letters, I will point out, were written by you, and they are in the court file. As to the third Youngins factor, this court sentenced Ms. Benefield to 20 years in prison. Neither that sentence nor the nature of the crime for which she was convicted justified denial of appeal bond. The use of a firearm in the offense is not a valid basis to deny bond. In Cooley v. State, and then they go on to quote Cooley v. State, which is the controlling case with regard to a firearm. I'm not going to read this whole entire thing because it's 16 pages and we're not going to have time before the hearing starts. Notably, Ms. Benefield was convicted of manslaughter with a firearm, an offense less serious than the offense for which the defendant was convicted of in Cooley, which is the case. Furthermore, circuit courts have granted post-trial bonds to defendants convicted of manslaughter. In State v. Trevor Dooley, now Attorney General Ashley Moody granted the defendant bond pending appeal despite his conviction for manslaughter with a weapon, improper exhibition of a dangerous weapon or firearm, and open carrying of a weapon. After being granted a new appeal on a successful Rule 9.141 petition alleging ineffective assistance of counsel, Mr. Dooley was again granted bond pending appeal. If the nature of the crime alone were sufficient to deny bond, it would render the fact-finding and application of the Youngins factors irrelevant. To conclude that the conviction for such an offense itself, without an examination of any facts relevant to the required Youngins analysis, would be akin to denying bond simply because of the conviction itself. Cooley also stands for the proposition that specific sentence does not deem the defendant a flight risk or ineligible for bond. Finally, other circumstances demonstrate that Ms. Benefield would not be tempted to remove herself from the court's jurisdiction. Ms. Benefield is dedicated to proving her innocence and that she acted in justifiable self-defense in a second trial. In light of the good faith issues Ms. Benefield intends to raise on appeal, along with consideration of the Youngins factors, this court should grant Ms. Benefield's motion for bond pending appeal. This court should set bond at a reasonable amount, with any reasonable conditions of release this court deems appropriate, and order that Ms. Benefield be released during the pendency of her appeal. Wherefore, Ms. Benefield respectfully requests that this honorable court grant her motion for bond pending appeal and that the supersedious bond be set at an amount that she can afford. And this is XOXO, William Ponall, P-O-N-A-L-L. I am told that he's one of the best appellate attorneys in Florida, and he will be handling the appeal if the funds can be raised to fund an appeal. Otherwise, she will be assigned to a public defender. Here's the order. This is Exhibit A. This is the order granting her motion for post-trial release pending appeal This is in a different case. This is in the Dooley case. So as grounds, he's citing an order by the now Attorney General of the state of Florida and attaching a copy of it. I wonder if it says what the offense was. Anybody know? Anybody familiar with this case? Trevor Dooley? Well, it looks like it's from 2013. But in his papers, he says the crime of Trevor Dooley was far worse than the crime of Ashley Benefield. So I guess that's all relative. Exhibit B, also in the Dooley case. And that defendant was released. He was 72 years old, not previously convicted of any crimes. He was released from custody and given a $100,000 bond pending the outcome of his appeal. I know, howdy, Dooley. Good one, good one. And so there's that. How's everybody doing today? Welcome, Penelope Jones. Thank you for becoming a new member. Welcome. I imagine the judge will rule on the bench on this, but if he does rule on the bench, she will be removed from the Manatee County Jail and taken to whatever women's prison they're going to put her in. I don't know the Florida system. Do you guys know how many women's prisons are in Florida and what the closest one to Manatee County would be? Okay, they have camera up. I'm going to put it up. Instead of the fan, we get the exit sign in Manatee County. You got to bear with me because I'm not in my usual setup. I don't have second screen. I'm trying to do all of this on one screen. And there's that. Oh, let's see, keep that there, put this here. All right, I got to turn on the air conditioning because I'm spritzing over here. So give me a second. I'll be right back. And I see the judge. It's hot here. It's hot here. I'm spending the weekend with my boyfriend, Dave Matthews, okay? All right? I know you're deadly curious, and so I'm going to tell you. My boyfriend, Dave Matthews, and I are going to be on the beach for 3 nights at some amazing, amazing concerts. So damn lucky. We even have a fire dancer emoji. We have a fire dancer emoji for members. Let me know if the background noise might be a little bit much. I may mute myself while the hearing is on. Just let me know. But it is what it is, because I don't like heat and I don't like humidity, as you can see from what's going on over here. No flat iron is going to save this situation. Sorry, Chantal. Sorry, Chantal. Ding, 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 ding. Thanks, Katie, for pointing out the obvious. Says, just commenting about how much folks debate about Ashley's credibility and not the state's case. True. There is not a GoFundMe set up yet. It will not be a GoFundMe because they do not allow fundraising for defense costs. There will be some other kind of fundraiser, like a Give, Send, Go or something. I believe it's being set up. As soon as I have it, I will let you know, because I know so many of you want to help, because so many of you found Ashley Benefield credible. I found her credible as well. I felt her terror was palpable still to this day. I feel like she's afraid of him, and it's tragic. And what happened is tragic. And the fact that Emerson will be without her mother for 20 years, this appeal is not successful, is also, in my opinion, tragic. Hi, Yuri's math teacher. Thank you so much for coming in and giving 5 memberships this morning. I appreciate you so much. And for the 5 of you that were gifted randomly by YouTube, welcome. I think you're gonna like it here, maybe. I'm not a neutral channel. When people come into my comments and tell me, you're so snarky, but you're only snarky for one side, or you're only, you're supposed to be neutral. I'm not supposed to be anything. I'm an attorney in New York with 30 years experience in state and federal courts, and my opinions shift based on the case. And it's not a bias. It's based on an educated review of the pleadings, the testimony, and the case itself. So when I come to you with my opinions, there's a difference between having educated opinions based on your research and having bias. I do not consider myself biased. I consider myself to have educated opinions, and you don't have to agree with them. But you also don't have to be mean about it. Thanks, Kale. No more AJ boyfriend. Guess y'all can move on. Well, that's where this started. This rumor started last year, when I said I had been in Cancun with Dave Matthews, and AJ was in the courtroom, and he had a bracelet on, something like this. This is like, a lot of people come here and they give swag away. They make things like, "Ooh, here's one that says, so damn lucky." And he had a bracelet on, and I commented, "Oh, that looks like a bracelet that I got in Mexico." And then the rumor was that I was in Mexico with Alan Jackson, and boy, that blew up the Twitterverse. I think it's still out there. People twist what you say, and they come to their own conclusions and opinions and make it their reality. Twitter is a cesspool. Don't go there. Thank you, Cal. Thank you so much. I don't even know if Alan Jackson likes Dave Matthews. I have no idea. All right, he's on camera, but the sound is not up. Oh, there's Neil Taylor. Hopefully the streaming works out. It doesn't lag. Like I said, I'm in another country with hotel Wi-Fi. Here's Ashley. And it's not always the best option. When I'm home, I'm on Ethernet. Neil Taylor told me that Ashley is doing extremely well because of her faith. That she just has faith, and he's really surprised. And I said to him, when we watched the sentencing, it just looked to me like she was disassociating. And he looked at me, he said, "You're exactly right. I think that's exactly what happened." I don't know. I can't hear their sound. If anybody's watching this on a different device on Law and Crime, tell me if their sound is up because I'm not getting any sound. Okay, thank you, Kale. Thank you. The facts of this case is that Ashley Benefield, when she was 24 years old, met a man named Doug Benefield, and they got married in something like, how long was their courtship, you guys? It was like super short. And during the course of their relatively short marriage, Doug exhibited signs of violence, including things like punching the dog in the face and rendering him unconscious, throwing the cat down the stairs, and various other coercive control red flags, including shooting a gun into the ceiling above her head to scare her. 15 days, was it 15 days before he proposed? Yeah. Eventually, they did have a baby together, and Ashley did everything she could to try and get away from him. On the day in question, they had been estranged for a while. She was moving from Florida to Maryland. He said that he was coming with them to Maryland. And so he was there at the house. He came over to help her pack the U-Haul or whatever. She got up and testified during the trial. She said that she thought she was going to die because I think he was some sort of martial arts expert or something. I don't recall exactly which martial art he was an expert of, allegedly. But she felt in fear for her life. There was a firearm in the room. She grabbed the firearm, told him to get out, told him to get, she was in her own house. He didn't leave. She wound up shooting him more than once. He died. She was tried for murder, but she was convicted of the lesser included manslaughter. Sentenced to 20 years in a Florida prison. The daughter attempted.
Yeah, I'm not going to use that one.
Okay. Okay.
Sir, you can stay at council table wherever you're comfortable. Judge, it's our position that based on the fairly debatable legal issues we intend to raise on appeal and an application of the Youngins factors, that a bond pending appeal is appropriate in this case. And we're going to present the testimony of 4 witnesses to help establish the Youngins factors. I would note that this was a close case where the jury found Ms. Benefield guilty of a lesser included offense. At some point during their deliberations, they were hung and came back to the court and advised the court of that. And I think they had at least one or more questions for the court. So again, it's our position this is a close case, and that under the circumstances, based mostly on Ms. Benefield's history and characteristics as a person, as well as her strong support from family and community, that she should be granted a bond. Thank you, sir. State, did you want to make an opening?
No, other than I think the court knows the state's position that we would oppose bond.
Okay. All right, Mr. Fidel.
The next call is Janelle Kiesmeyer.
Okay. The evil stepsisters whispering into their hot mic might just drive me bat duck insane. I don't know why they can't figure out there's a mic in front of them that they can mute, but it's just so annoying.
She'll be the truth, the whole truth, and nothing but the truth.
Up, down, left, right if you needed to.
Thank you.
Good morning.
Good morning.
Could you state your full name
Sure. Janelle Kuzmeyer.
and how are you employed?
I am a supervised release officer with Manatee County Probation.
How long have you been doing that?
Coming up on 10 years.
Do you know the defendant in this case?
I do.
How do you know her?
I was her supervised release officer for 4 years.
How long was Miss Benefield out on bond?
She was out on bond for 4 years with me.
And did you monitor her that entire period?
I did
Was Ms. Benefield on GPS monitoring when she was released?
the whole time, yes.
Did she ever violate any terms of her monitoring?
She did not.
Did she ever violate any other terms of her release?
She did not.
Did she abide by the terms of her curfew?
Yes, she did.
And did you have any issues with Ms. Benefield otherwise?
I did not.
Did she keep in contact with you?
She did, yes.
Was she honest with you?
I'm sorry.
Was she honest with you?
As far as I know, yes.
Okay, I can't make the audio louder. I can make myself softer, so I just decreased my volume. So tell me if my volume is now equal with this volume, so you can turn your volume up. Because I don't know if you're wearing earbuds, it'll blow you out when I talk, so just let me know.
Did Ms. Benefield maintain employment while she was out on bond?
Is that better?
She worked for several different employers, but I don't know if it was consistently through the 4 years, but she did have several different jobs.
Were there times during your monitoring period that the court granted Ms. Benefield permission to travel outside of the jurisdiction?
Yes, one time out of state and at least, I believe, 2 times to Orlando.
Did she keep you advised of the details of that travel, including dates, times of when she was leaving and returning and where she would be staying?
Yes, she was very good about communicating those things.
Do you have any reason to believe that Ms. Benefield would be a flight risk if released on bond pending appeal?
Based on my 4 years with her, I don't have anything that jumps to me thinking that she would flee.
Thank you. No further questions.
Cross.
No question.
Can the witness be excused?
Yes.
State.
Yes.
All right, ma'am, you're excused. Thank you very much.
Thank you.
All right, your next witness.
The defense calls Dr. Barbara Russell.
Remember Barbara Russell was her therapist, who then I think became her friend and then actually let her move in with her. So we heard from her probation officer. Now this is Barbara Russell.
We'll call Laura Zito.
Wait, what happened?
In the meantime, we'll call Laura Zito.
Hold on a second. Maybe she's not there yet. Stuck in Florida traffic. Oh, you know what? Didn't it snow in Florida? And they probably have no plows. So is the snow still on the ground in Florida, my Florida friends?
In the meantime, we'll call Laura Zito.
I don't know. I think there was a motion that Eva Benefield and Tommy
Do you
Benefield
solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth,
could appear by Zoom, so I don't see them in the courtroom, Tommy and Eva.
and nothing but the truth?
Morning, ma'am. And that does adjust if you need to move it up, down, left, or right.
Okay, thank you.
Good morning.
Good morning.
Please state your name.
I agree.
Laura Zito
Where do you live?
in Manatee County
How long have you been living in Manatee County?
for 8 years.
What do you do for a living?
I'm a stay-at-home mom.
And how long have you been a stay-at-home mom?
7 years,
How many children do you have?
5.
Oh, wow, 5. Do you know the defendant in this case, Ashley Benefield?
I do.
How long have you known her?
For just over 9 years.
Did you and Ashley spend time together with anyone else? Any other friends in your group?
My husband.
How about
Mm.
other young mothers?
Throughout all the years, it was pretty much us two.
Okay.
Yeah. There are a couple times where we had other people around at gatherings and stuff, but we would hang out together.
Okay. Could you describe for the court who Ashley is as a person?
She is a very genuine, honest, loving, giving, very gentle person.
And have you had the opportunity to observe Ashley as a mother to her daughter?
Yes.
Could you describe how she is with her daughter?
She's very loving, very patient and kind. She's attentive. She's helpful in every way, just always ready to do anything for her.
And have you continued to support Ms. Benefield since the incident in this case?
Yes,
And if she's released on an appellate bond, would you continue to support her?
yes.
Do you have any reason to believe that Ms. Benefield would be a flight risk?
No.
Thank you. No further questions.
Cross? Hold on, ma'am.
Sorry.
It's all right.
She's like, I'm out of here.
All right. Now you're all set.
This is the first time I've seen Ashley smile in court too.
The
Nice.
defense calls Jana Martin.
Stand right here, please, face the clerk, raise your right hand if you sworn in.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes. This way, please.
Good morning, Judge White.
Good morning, ma'am. As you sit down and make yourself comfortable,
Yes,
that microphone adjusts up, down, left, right, however you need it.
thank you.
Good morning.
Good morning,
Could you state your name for the record?
Jana Taylor Martin.
Oh, we've
Where do
seen
you
her.
live?
I live at 2510 Loma
Oh,
Linda
don't
Street,
tell us where you
Sarasota,
live.
Florida.
Don't. People will.
And how
people,
long have you lived in the Sarasota area?
Almost 40 years.
we saw her in court every day of the trial and we were wondering who she was. These are all character witnesses on behalf of Ashley in support of her motion to be released on bond pending appeal.
What do you do for a living?
Well, right now I am a missionary and a Bible teacher and a chaplain. But I started out as an elementary school teacher and I sold real estate 40 years.
And do you know Ashley Benefield?
Yes, I do.
How did you meet her?
I met Ashley in 2016 when I was called to do a prayer initiative for President Trump, and she was the coordinator between President Trump and the women that prayed and interceded for him.
And is it your understanding that Ms. Benefield lived in the Bradenton or Sarasota area since 2016?
Yes, she did. She lived first with Barbara Russell, and then after approval, she moved into our guest house, 15 steps from my back door.
And in the time that you've known Ms. Benefield, did she have family and friends in the Manatee County area?
She did.
And did you and Ms. Benefield participate in any church groups?
She was in my Bible study. Even her little Emerson, that's 7 now, and her mother, Mimi. So yes, she did, and I have.
It'd be helpful if I unmute. We have not seen Ashley smile through the entire course of the trial. And this is what Neil Taylor was telling me the other night. He said her faith keeps her going. And he said she's doing remarkably well because I was so worried as you were about her and her condition and how she was. And he said her faith keeps her going. She has faith. I'm not muted anymore. You might be behind or there's a little bit of a lag. I fixed it. We're good, right? We're good. And now you can see. This witness, she went to her Bible study, etc.
I've been walking with Ashley for 9 years almost.
And how often did your Bible study meet?
A weekly.
How many people participated?
It's all women, and it would vary anywhere from 8 to 14, except one time a man came. One man. That was all. And it was just pretty much focused on the Bible and the way to walk with the Lord.
And were there, you mentioned that it was mostly women. Were they women of all ages, from young women to senior citizens?
Yes, they were all ages, and they were from different churches and different walks of life.
And to your knowledge, is Ms. Benefield close friends with any of these people that she met at the Bible study?
Some of them are sitting right there in the courtroom. So the answer is yes.
And do the members of the Bible study, do they continue to support Ms. Benefield?
Yes, not only with love, but they've helped financially also. They've stood with her 100%.
And you mentioned that Ms. Benefield lived with you at some point in your guest house?
Yes, she did.
When did that start and how many years? was it?
After this happened, after the incident, she was with Barbara Russell. She wasn't allowed to come be with her daughter in Emerson until it was approved by the powers that be. And then they came to our guest house and we prepared it properly. And we met all the regulations for it. And my husband, which I just lost, it was never any cost. We're blessed to be a blessing. We loved having them there. It was a great gift for us to have them. Yeah.
I'm sorry for your loss.
Yeah, me too. He
Um,
was great.
and you kind of mentioned it. Did you charge Ms. Benefield rent?
Never, not one dime. I didn't want it. We wanted her to be there and be safe. And we believe she was.
And at the time that she was living in your guest house, was she working?
She was. Different jobs at different times and always obedient. I remember I have to be here at this time. It was always, she was very obedient about being on time and right. And yes, she did have different jobs.
And could you describe for the court who Ashley is as a person?
She's precious. I've never heard the child say a curse word. She's mature beyond her age. And she had a position with Mr. Trump, whether you liked him or not, that she did a great job. She was obedient. She had a good position. She led the prayer team. And we prayed for months for Donald Trump before he won. She is a lovely, smart, outstanding, godly girl. Is that enough?
Yes, that is enough. Thank you. And did you have the opportunity to observe Ashley as a mother?
Impeccable mother. As a child, I would go to the cast.
If you're not looking at the screen, you might want to look at the screen. If you're driving, wait until you stop and come back to it later. But Ashley's crying. Her hands are cuffed. She's trying to wipe her tears away. This is heartbreaking. This woman is one of the best character witnesses I've ever seen in a hearing like this. But boy, does she love Ashley, and she just lost her husband, and now she's lost Ashley, and oh, heartbreaking. Get the tissues.
House, and she'd be holding Emerson. They'd be talking about dinosaurs. They'd have books. They'd be watching shows. She was an impeccable mother. She put her first. She had her in a ballet. She had her in swimming. She had her in tap. She did everything she could to support Emerson, and still is. And I wish she could be with Emerson and supporting her now.
How old is Emerson?
7.
And to your knowledge, did Emerson participate in any programs or activities in the local area?
Absolutely. The Nutcracker with the Sarasota Ballet.
Anything else? Any like?
If I may. At my husband's
Go,
funeral
sis, go.
last week, they asked for people to speak. Emerson came up the aisle in her cowboy boots, and she took the microphone, and she turned around and she said, "I love my Papa Jim, and I understand because my cat died."
Last week.
It's a precious child.
Last week. All right, I got to get some tissues, but last week, Emerson is 7 years old. She just turned 7 because when the motion papers were filed, she was 6. She just turned 7, and this woman is like another grandmother to her. Imagine a 7-year-old getting up at a funeral to make remarks. It's remarkable. Ashley's a good mother. No matter what you say about her or think about her, she's a good mother.
She's missing her mother desperately. But I had a smart son. She's bright. She's very, very bright.
Thank you, Ms.
It's
Martin.
just, I know I may be saying too
No,
much.
that's
I'm
okay. I didn't mean to
sorry.
interrupt.
Uh,
If Ms. Benefield is granted an appellate bond, where would she live?
She would live 10 steps from my back door.
Kurt, I don't even know what the fuck this, oh, I'm sorry, what the duck this comment is supposed to mean. She's 7 years old. Her cat died and she got up to speak at the man's funeral, who she considers to be like another father to her. So what is the purpose of this comment? Other than to just cause some discord in my chat, which I don't appreciate. I wouldn't do that to you. And you know my audience, and you know that I have many, many survivors of domestic violence in my audience. So a comment like that is so over the top, I can't even.
Is that in the guest house or somewhere else?
Actually, it's in another house we own next door that's bigger and more room, where I think they could be a little more comfortable. The guest house isn't that big.
And would she be living there with anyone else?
Yes,
Would it be
her
Dr.
mother and Emerson. And it would be no charge.
And how are they already living there? Her mother and Emerson.
They are.
Do you know how long they've been there?
Yes. Whenever Mr. Neal, I mean, it was around Thanksgiving. Don't hold me to that,
So
but
a couple months.
yeah.
And if the court were to impose conditions of release such as an ankle monitor or curfew, would you help her in complying with those conditions?
Absolutely, 100%.
Do you have any reason to believe that Ms. Benefield poses a flight risk?
Never. Absolutely never. Absolutely never. I believe with all my heart, she would be obedient. She was obedient the last time. I think she would be obedient again.
Just one moment. And would you be willing to be sort of like a custodian for Ms. Benefield? If you notice any violations, would you report them?
Yes, and I'd be a good custodian because I tell the truth, and I would be obedient as a custodian, and it would be my honor. If the judge's heart would see it, it would be an honor for me to be a custodian at this time. That's going to be hard for me to be alone with. I'd love to be a custodian.
And since Ms. Benefield's arrest, have you been providing her with emotional support?
Yeah,
Will you continue to do so?
absolutely. With prayer, with guidance, and we're going to walk this out, and the Lord rules.
Thank you. No further questions.
Thank you, Judge.
Hold on 1 second. Cross?
No questions.
Okay,
Thank
now
you.
you're all set.
Thank you, Judge.
Thank you, Ms. Martin.
Love this woman. Love her.
If it would be possible if we could try to see if Dr. Barbara Russell is out there now. Yes?
Waiting on Dr. Russell. Yeah, Kurt says he misunderstood the testimony that she's 7. Kurt has also openly mocked Ashley Benefield on his channel and her testimony, calling her Amber Heard and like relentlessly mocking her. And Kurt, you know that my chat is sympathetic to Ashley. And my opinion is that you're coming in here to cause trouble, and I'm just not going to have it. It's not cool. And I'm not going to let people bash you in the comments or bash you in my chat. But like, who does that? Why would you do that?
Stand here, please. Raise your right hand and swear.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
God, I do.
Good morning, ma'am.
Good morning, Your Honor.
Just adjust the microphone however you need.
Okay. Good morning.
Good morning.
If you could please state your name for the record.
Barbara J. Russell.
And what do you do for a living?
I have a mental health practice. I do clinical and forensic evaluations and counseling.
How long have you been doing that?
I'm here in Florida for about 15 years.
Do you know Ashley Benefield?
I do.
When did you meet her?
I met her in the spring of 2020.
What were the circumstances of that?
She came to my office seeking an evaluation.
And how long have you had a professional relationship with Ms. Benefield?
Pretty much ever since then.
And did you continue to communicate with her after the shooting incident in this case?
Yes,
Did Ms. Benefield live with you at some point?
yes.
Do you recall when about that was?
Late October of 2020.
And how long did she live with you?
Approximately 8 months until her DCF case was resolved.
And why did you allow her to live with you?
Because I don't think I ever could have held my head up high or looked my kids in the face if I didn't. She was severely traumatized after the shooting incident and everything that had happened prior to that. And because of the DCF involvement, she was not allowed to live with her mother and daughter, and she was effectively homeless. The financial abuse in her marriage had robbed her of all financial resources. And I could not abandon a client and say to her, well, good luck sleeping in your car. I hope you get your kid back. It was out of the question.
Did you charge her rent?
No.
See, so many people really trashed her during the trial for letting Ashley move in with her, and now she's explaining why. She would have been homeless. The court wouldn't let her live with her mother and her child, and she wasn't going to turn her back on her. Not necessarily the most ethical thing for a therapist to do, but she's a human, and she seems like a very kind human. And we need a
Is it
little
fair
bit
to say
more.
we're
We need a little bit more kindness in this world, if you ask me.
trying to help her through a difficult situation to the best of your ability?
Yeah, I had an obligation not to abandon her and to make sure that she was safe and that her daughter's mother continued to be safe.
To your knowledge, how long has Ms. Benefield lived in the Bradenton, Sarasota area?
I believe she moved here, it was like 2012, 2013. She danced for the Sarasota Ballet. She continued to live here after her retirement from the ballet. She did live in South Carolina for a couple of years in the early part of her marriage to Douglas Benefield, and then returned to the Sarasota Bradenton area afterwards.
To your knowledge, does she have any ties to the local community?
Oh yeah, she has many ties in the local community.
How about a church community?
She has a church community. She participates in various Bible studies and she attends a Torah club as well.
What is a Torah club?
It's like another Bible study. It's a weekly gathering and studying of Torah, and she has friends and fellowship in that group as well.
Are you aware of Ms. Benefield participating in any pro bono work?
Yes, she was working for Elite Teams Ministries, doing a variety of things, some youth mentoring as well as social media marketing.
And could you describe for the court who Ashley is as a person?
Ashley is a very loving mother. Ashley is kind. Ashley is compassionate. She's a good moral compass. She's just an all-around great girl.
You mentioned that she's a wonderful mother. To your knowledge, is her daughter involved in any extracurricular activities in the Manatee County area?
Oh yeah, she's been in the ballet for several years. She's participated in swimming lessons and is involved in different, social activities. She has a lot of little friends.
And have you had the chance to observe the impact of Ms. Benefield's absence on Emerson?
Yes, I've seen Emerson a couple of times since her mother's incarceration. She misses her mom. She just wants her mommy to be with her.
And have you assisted Ms. Benefield in getting a job if she is released on bond?
Yes, she has a job waiting for her.
And what is that?
She would be working at Bishop's Aluminum. It's a corporation in Sarasota. They make the aluminum parts for pool cages.
Do you know what her role would be in that?
It would be physical labor. She would be starting out like in the factory doing prefabrication work, and she can move up to assembly.
And since the incident in this case, have you provided emotional support to Ms. Benefield?
Yes,
Will you continue to do so if she's released on bond?
of course.
Do you have any reason to believe that she would flee if released on bond?
No, that's the last thing she would do. She would never abandon her daughter, and Ashley would follow the rules. She would do everything the court told her to do. She is a rule follower. She's always been very structured, methodical. She follows rules. She does things the way they're supposed to be done.
No further questions from the defense.
Cross?
No.
All right, thank you, ma'am.
Thank you, sir.
She meets all the conditions. She has a job. She's not going to flee. She has a child here. She has a place to live. The judge is never going to get it. Judge is never going to grant this motion, but
Judge, we don't have any other witnesses. We have, with the court's permission, there's several people in the audience here in support of Ms. Benefield who are also willing to act as custodians if the court were to grant a bond and to report any violations they became aware of. We've explained to them that if they were assigned that role and failed to do so, they could be held in contempt.
he can't seem to find the mic, so you're going to have to rely on closed captions for this.
So with the court's permission, I'd simply like them to stand up and state their name for the record.
Okay.
Anyone who's here.
Each of these individuals in the audience is willing to serve as custodian, and rather than have them testify, he said, "Judge, can they stand up and tell you their names?" And the judge said, "Okay."
That is willing to act as a custodian for Ms. Benefield, as we explained, please state your name for the record, starting with you.
Pamela Hagan. James Bergen. Susan Burke. Laura Zito.
Michael Zito.
Jana Martin.
Thank you.
I heard at least 6 people in the audience say that they would be willing to serve as her custodian.
We don't have any other evidence or testimony, just legal argument.
All right. State, any evidence, witness, or testimony?
Judge, I don't have any evidence. I do have a member of the family that would like to speak,
Okay.
Mr. Tommy Benefield.
Oh, Tommy's here. I didn't see Tommy before. Tommy, Tommie Benefield, Doug's cousin,
Yes.
who claims that he knew Doug so
Alright.
well,
Go ahead.
yet he had no idea who Ashley was and didn't even know that they got married. Guess he wasn't invited to the wedding party or the party that they had after their wedding.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
It is, yes.
And this is a statement pursuant to Marcy.
Wouldn't it be so amazing if he said, "In the interest of justice, I would like you, judge, to release her on bond so that she can be with my cousin's daughter because Emerson needs her mother"? I don't know. Tommy's also the one who tried to get with Ashley, remember? He sent her those text messages.
She's long.
Yes.
Okay.
it is.
Thank you, Your Honor, for hearing from the family today. As has been spoken in court today, it has been over 4 years since the defendant or the convict killed Doug Benefield in a single shot killing that has been a conviction of manslaughter with a firearm. There are 2 sides to Ashley Benefield that have been portrayed throughout my longtime association through Doug to Ashley, through all of his business friends and partners who got to see Ashley from the very beginning of the relationship. There are believers, they're in this room and they're elsewhere. And there are people who saw through the actress that we have seen over time. Of that 1,597 days since the killing, she's been out of jail. She was fortunate enough to be allowed out during the COVID time, which allowed her to be on an ankle bracelet and with their daughter from basically 3.5 years old to she'll turn 7 in March. Most of that time, it's almost 90% of the time since the killing, she's been out of jail.
So is that enough, Tommy? Is that enough? Is that she had enough time with her daughter? The daughter had, Emerson had enough time with her mother? I bet you anything they're going to fight for custody if they haven't already filed.
She was fortunate enough to get that time. It's clear that the believers, from our point of view, have supported her with money this whole time. But the part of the story that's not told, and I have access to every bank record our family does, even the week before the killing, Doug had to borrow $25,000 to support the move of Ashley, Alicia, and Emerson to Maryland. And it was just a few days before that he needed the money to even move.
Wait, he had to? Or he had so much financial coercive control over her that that was another way of controlling her by paying for the move, because he was going to move too. In fact, he shared that moving truck with her and he loaded all of his stuff in the back. so that would give him more time with her instead of loading his stuff in the front the way she wanted it so that he could get his stuff off the truck first and then leave her alone. Wow.
The family, I'll call it, up to Maryland. So for him to be portrayed as not supporting her is just a lie. We have the bank records, we have the money transfers. So many things in this portrayal today is one side of what she can present. But the reality of Doug paying for her counseling, their marital counseling,
Financial
providing money,
control.
paying for clothes purchases, predominantly paying for almost everything that Emerson required up until the time he was killed. The other part of the portrayal today that Doug did not support her and left her destitute.
Wow, he supported his daughter financially. What a guy. What a guy.
Or not that word, but close enough, is that the supporters have made that happen for her. However, the financial support and the jobs that are talked about, I'd love to know, and the family would love to know, the very few times that she worked during that period. And if we remember back to the first case, especially in court testimony, she was allowed to get out with a job, supposedly with her attorney previous to this case in the child custody and divorce case. That job didn't last. There are witnesses from her work period while she was out on bond previously that have a very different story to tell of who Ashley Benefield is. Since the sentencing and her not getting out, they have come forward. So there's a very different picture of
It's a more.
He objected based on hearsay because someone told him that. I know you can't hear him, so I'll just repeat it. It's important.
Mercy's law statement. Overruled.
I respect.
This is not evidentiary. This is not evidentiary.
And I respect the ruling. For the record, I'd like to rule.
Overruled.
Yeah, it's overruled because the judge says the rules of evidence don't apply to this hearing. So basically, Tommy can get up there and say whatever he wants. Right on.
Thank you, sir. From the first night that I spent the night in Ashley's mother's home, I believe in the room where Doug was killed.
Oh my God,
The
really?
next morning, I told Doug at coffee I would not stay in the house anymore due to the evil in the house that was not presented, but how I felt about being there. And I went to a hotel that night and stayed. So I've been around Ashley for many years personally. There are other people who, matter of fact, Trip Cormany, who married them. I know for a fact that she can present two ways.
So you know who married them, but you were not at the wedding and you didn't even know that he got married. And now you've inserted yourself all over this case. And you guys weren't even that tight when he was alive. And I think we saw a lot of testimony to that. But now he sensed evil in the house, in Ashley's mother's house. He sensed evil. And even over coffee, he had to leave. And that was when Doug was alive.
And she has throughout this case. And if you believe her, then this is a case of that. She's had the financial support to get through all of these trials and all this time, all of these attorneys, without her paying for them. So I do believe, and the family believes, that she has the ability, especially now that she's been sentenced to the 20 years and 10 years, and she's had financial support all along, that would be very simple for her to avoid this prison time by having supporters provide money for whatever they say it's going to, and it's very simple to get out of the United States and disappear. We believe as a family.
Really? Really, dude? He's just going to leave her. She's going to leave her daughter. Like she wouldn't have to surrender her passport.
As the supporters of Doug, that she's not the same person now, nor would she necessarily behave the same way as she did in her first bond period for 1,300 days. We do not believe at any point, the last part of what the family, and I'll call it family, is that there is family of hers that would not come forward to speak with us and tell us the truth about how threatened they felt. Direct family of Ashley's, who has now become friends and family of ours, who would not come forward until the sentencing was done for fear of how she would do retribution on them. So,
Oh, there's people out there that are afraid of Ashley that won't speak. Are they in the courtroom? Call them up to the stand, Tommy Benefield, because I'm not buying what you're selling here.
her own real family outside of the people of Emerson and Alicia, but other members of her direct family don't believe she will stay, and she will stay during the bond for the appeal to be answered. They can't.
Her own family told you that she's going to flee the country? This is so much hearsay. There's no evidentiary basis for this, but like the judge said, it's not an evidentiary hearing. Tommy's just going to get to say whatever he wants to say.
Be here today. They still feel that it would be dangerous for them to speak in person. But as a family, we don't believe that she will stay through any bond that she has. She's been out 90% of the time since the killing, and we believe that she's had the benefit of all that time with their daughter from 3.5 to almost 7. It won't hurt to keep her in jail. She should be kept in jail during this period. Thank you, Your Honor.
Thank you, sir. Any other statements?
Judge, I believe that's it.
All right, and no evidence?
No evidence. I just have argument.
All right. I'll consider the evidentiary portion of the case closed, or the hearing closed. We're prepared to hear argument.
Did you see? He just corrected himself. I'll consider the evidentiary portion of the hearing goes, oh, no. That's right. I already said it wasn't evidence because I let in all that hearsay. So yeah, no, I didn't mean it was an evidentiary hearing. There was no evidence. I just meant, the hearing part is closed now. Now we're going to get to hear closing from evil stepsister number 1.
Judge, I'll start by saying I certainly feel horrible for Mr. Benefield's loss, but I'd ask the court not to consider the speculation and the hearsay testimony about family members that are not coming forward and individuals that are making statements that can't be substantiated. As it's our position under Rule 3.691 and the Youngins case that Ms. Benefield is entitled to a bond pending appeal. As the court is aware, under the rule and the case law, the defendant is normally, and this is from the Baker case that I provided to the court, it says a convicted defendant should normally be admitted to a bail pending appeal if the appeal is taken in good faith on grounds not frivolous but fairly debatable. So it's normally, this isn't an exception, this isn't a rare occurrence, it's the normal course of business unless there's factors that suggest it's not appropriate. And the good faith requirement for purposes of appeal is simply to raise claims that are non-frivolous on appeal that are fairly debatable. I think ad nauseum, the issues that are going to be raised on appeal have been addressed to the court. I think the court would be hard pressed to find that we don't have any fairly debatable issues. I'm not going to go through all of them. I will just point out that I believe there's a fairly debatable argument that the state's closing argument misrepresented evidence. There's a fairly debatable argument that Juror 15 committed juror misconduct that justified a new trial.
Yep.
There was a significant number of rulings by the court prohibiting introduction of evidence that would have supported Ms. Benefield's defense. We think we have a legitimate argument that the state did not meet their burden of proving beyond a reasonable doubt that Ms. Benefield was not acting in self-defense. So there's a variety of issues that I think meet the very low threshold of fairly debatable. And I'd be surprised if the state disagreed that we meet that standard. Once we meet that standard, we move to the Youngins factors. And And there's 4 of those. And the first is the habits of the defendant as to respect for the law. As the court knows from the sentencing hearing, from the PSI, this is Ms. Benefield's first criminal incident. So she has a long life of not being involved in any criminal activity. And we also know from her pretrial services officer that she was a 100% obedient person on pretrial detainee with no issues, following the requirements of electronic monitoring, following the requirements of a curfew, following all the requirements established by the court. So it's our position that under the case law, the habits of the defendant as we respect for the law weigh heavily in favor of Ms. Benefield being granted a bond. I don't think there's any evidence to contradict that in any way. The second issue is her local attachments to the community by way of family ties, business, or investments. We've heard testimony from today, and the PSI notes that both Ms. Benefield's mother and daughter live in Sarasota, and that Ms. Benefield has lived in the Sarasota-Bradenton area since at least 2016. She has a home that is being given to her to live in by one of her friends, a longtime friend who testified here today. We also have the testimony of Barbara Russell, who was willing to give Miss Benefield a place to live when she was in a time of need. It's hard for me to imagine a stronger showing of support than providing an individual that doesn't have a place to live at no cost. We have a letter from Reverend Brown indicating that she's strongly involved in the community, in prayer groups, in the Torah Club. We have other testimony about her involvement. It's clear that she is tied to this community by family, friends, and work. We have a letter indicating that she has a job waiting for her, and she's ready and willing to start that job to support herself and her daughter when she's released. The third factor is the severity of the punishment imposed. And I would certainly be disingenuous if I argued with the court that a 20-year sentence is not a lengthy period of time. But the Cooley case from the second DCA, 1998, gives a pretty good discussion of how to weigh the sentencing, the sentence. And in that case, they talked, the trial judge denied bond because Cooley was facing a minimum mandatory sentence. And what the second DCA said is they have the authority, the legislator has the authority to exclude certain crimes or certain conditions from when people could be granted a bond. So if they wanted to, they could say anyone that was sentenced to more than 10 years or anyone that was sentenced to a crime with a firearm is precluded from being granted a bond. As the court is aware in its earlier order on the bond issue, there is actually a statute that lists crimes that you cannot get a bond for. Manslaughter with a firearm is not one of those crimes. So although the 20-year sentence, I would say, does not mitigate in favor of Ms. Benefield, I think the case law, including the Cooley case, indicates that that factor alone is not sufficient to justify a bond. Same issue is addressed by the 4th DCA in the Baptiste case.
Baptiste?
Yes, Baptiste, 4th DCA, 2012. They cite back to Cooley and again say the length of the defendant's sentence is not by itself evidence of flight, and that's the purpose of bond, is to prevent flight. The fourth factor is any evidence that Ms. Benefield would be tempted to remove herself from the jurisdiction of the court, and I suggest there's no evidence of that. In fact, we have the contrary. We have 4 years of strict compliance with the rules. We have years and years of compliance with the laws of the United States and Florida. We have numerous individuals in this courtroom willing to act as custodians and to report any violations. All we have is speculation that potentially someone with a 20-year sentence would be tempted to flee, But again, the case law makes it clear that that fact alone, just the sentence, it has to be tied to a specific fact or something else. You need something else besides the sentence to support the denial of a bond. And with the strong support exhibited here today, it's my position that Ms. Benefield, there's no evidence she's likely to flee, and everything she's done up to this point is consistent with her attempting to exonerate herself based on self-defense, and she continues to want to do that through the appellate process and through whatever means she can. There's simply no evidence that she would leave the jurisdiction in this case. Finally, I point the court to the Dooley case from Hillsborough County. It's a similar circumstances as this. Mr. Dooley, and I met Mr. Dooley, so I have personal knowledge of the case. Mr. Dooley was convicted of manslaughter with a firearm based on an incident which he claimed self-defense. And he was sentenced to 8 years in prison at the age of 72. And two different judges, then Judge Ashley Moody and then Judge Barber, granted bonds pending appeal based on the fairly debatable issues and his history of complying with the conditions of his release. It's our position that the circumstances of this case are similar to those in Mr. Dooley's case. And the Dooley case is an example of why an appeal bond exists. The purpose of the appeal bond is twofold. One, if a person has a good faith appeal and they win it, they really don't deserve to serve the time if the appeal is won. And secondly, it's to ensure that they don't flee the jurisdiction. But so it's our position that the Dooley case, again, is similar to Ms. Benefield's, and we'd ask, and in that case, they imposed a bond of $100,000 and various conditions, including travel conditions and GPS. We recognize that the bond in this case was $100,000 prior to trial. We recognize that the circumstances are different after trial, and the case law says that it makes some sense for the bond to be a little bit higher following a conviction, because the concerns are different. So we'd ask the court to impose a bond of $150,000 with the same conditions that were imposed pre-trial. To remind the court, Ms. Benefield has previously surrendered her passport. She's perfectly willing and able to submit to GPS monitoring and to have a curfew as she did before. And finally, I'll note that there was at least 2 occasions where the state agreed to Ms. Benefield to travel, once to Orlando and once out of state, where she traveled through various states and went to Maryland and Washington, D.C. And those 2 orders have been entered into evidence. So even the state prior to trial was not concerned about Ms. Benefield fleeing the jurisdiction. And at that point, she was facing a charge of second-degree murder with a firearm, where she could get up to life in prison. So any incentive she had to flee existed then as well, and she remained dedicated to proving her innocence and proving her claim of self-defense, and she remains in that same position today. So we'd ask the court to grant the bond pursuant to those terms.
Thank you, sir. State.
Judge, first I'd like to address the Dooley case that defense brought up. And
Okay, get ready for evil stepsister number 1. Here she goes. Take a deep breath, everyone.
also to state for the record that I have read all the case law that the defense provided, and I've read through this Dooley paperwork that was provided. I disagree that it's exactly like this case. The Dooley case couldn't be further from the truth. Mr. Dooley was like 72 years old. He shot a stranger in his own home. He was given a supersedious bond and turned himself in when he lost his appeal. And then when it went back where it was going to all start over, they gave him a bond again. So he had already demonstrated after the sentence that he could come back and turn himself in after the appeal. He lost the appeal. So I don't think Dooley is at all analogous to this case. Also, I don't think any of the cases that defense cited, while some of the factors may be similar, I don't think that they are analogous because these things are so fact specific. And most of the cases that the defense cited, the court did not rule with enough specificity or with enough facts. And the appellate courts found their orders to be lacking. So the vast majority of the reasons that these cases were overturned was because the proper factual findings were not made by the court. And that's individual to each case. So the case law says that a denial by the court must be based on record evidence, which the court's been here from the beginning, been to all the hearings, been to the stand your ground, been through the trial. You've gotten a plethora of record evidence that you can draw from. And also the court can consider any reasonable inferences from that evidence or that record evidence. The question is, what are the factors that distinguish this defendant from other defendants that maybe are charged and convicted with manslaughter or manslaughter with a firearm? What is the difference? And that's what I want to concentrate on, because that is the factor of the severity of the sentence and the specific factors of this case. I would agree, the state is not making an argument about the frivolous appeal issue. The state is not making an argument that she does not have ties to the community. There are issues with the fact that while she was out before, she never had consistent work, and she always relied on other people to fund her, and she is still relying on other people to fund her. However, but the state's main argument is going to be about the length of the sentence and the specific factors of this case that should tell the court that she is likely not going to show up after she loses an appeal. This case,
I think that's a ridiculous
manslaughter
argument. I think her better argument would be that her appeal is going to be unsuccessful. I think that's a terrible argument that she's going to flee. Like, does anybody really think she's going to flee? She's so meek and she's so shut down. She can barely even raise her eyes. Do you really think that she's going to flee the jurisdiction with an ankle monitor and a $150,000 bond? I don't know. I just think that's the wrong argument for her to make. I think she's got better arguments to make if she really wants to shut this down. And this is not the one she should, not the hill she should die on, in my opinion.
for the firearm, it was not a knee-jerk decision. It was not kids playing in the back of a car with a firearm that accidentally goes off. It was not a homeowner that shoots the pool guy because he thinks he's an intruder. It was not a DUI manslaughter where someone is drunk and accidentally hits someone. This case is very, very different from all of those other manslaughter with a firearm cases. This case is unique. This was the culmination of a 3-year campaign that started when she got pregnant.
Right,
And the
right,
campaign
right.
started
Because she
then.
really, really, really wanted to be a single mother. And she really, really, really wanted him dead. And she really was not afraid of him at all. It was a 3-year campaign. This was a campaign culminating in a killing. Okay.
And she kept with that campaign all the way through the day that she killed Doug Benefield. And she not only stuck with that campaign, but she adjusted.
So wait, she wanted him for his money. So she killed him so she could have his money, but he was broke. So that argument doesn't make any sense. If you're going to argue that she relied on him financially and he spent $25,000 and he didn't even have the money and he didn't have any money. What was the benefit in killing him for her? Aside from risking 20 years in prison. I don't know. The argument doesn't make sense to me.
And she changed and she adapted to the things that were thrown her way. She started, for instance, with an injunction in South Carolina. When that didn't work, she tried to get an injunction here in Florida. When that didn't work with allegations.
Again, she's minimizing any justification for having these restraining orders against him. When that didn't work, she tried this. When that didn't work, she tried that. Yeah, when they didn't enforce the North Carolina order of protection, she tried to get one in Florida because the cop laughed at her and thought she was a pain in the neck for even asking him to try and enforce it when he was put a low jack on her car and was tracking her and stalking her and tried to rent the house behind. Really?
Of violence against her.
How dare she?
Then
How dare she try and protect herself from an abuser? How dare she try?
she started saying there was violence against the child. And when that didn't work, then it was sexual abuse against the child. She adapted her behavior every time the system told her no. This is a very calculated.
Women of Manatee County, I pray for you. I pray for you. I pray for you. Because they will not take you seriously in Manatee County. That is what she is telling you. She's minimizing it. She's almost mocking it. Mocking the fact that a domestic violence victim who's in fear for their life should go seek a restraining order against the perp. Is it me?
Set of behaviors by the defendant. When all other options failed, she shot Doug Benefield to achieve her goal. And we all know the goal was to have sole custody of her child. And I've heard a lot of people today say that Ashley's honest and truthful, but I've also heard, and I think the court's also seen, that there are different sides to the defendant. And I think the court can consider the fact that a different judge, Judge Moreland, in her order before, specifically found that she was not credible. She was dishonest with the court and was not telling the truth. So if the court is to believe these friends of the defendant, the court can also take into consideration that another judge found her to be completely dishonest and not credible. This trial was her last attempt to keep her child. She'd already achieved the goal. She'd gotten rid of Doug. So this trial was her last step. And
right, because she wanted to be on trial for murder. And she wanted to risk the 20 years in jail because this was all part of her grand scheme, her big plan, her big plan.
to be honest with you, I don't think she had an inkling that this court was not going to, or that this jury was not going to believe her. I don't think in a million years she thought she was not going to be able to convince this jury.
Anytime somebody says to be honest with you, they're about to say something that's not honest. You ever notice that?
But she didn't. And after the trial, they told her they did not believe her. Her version of events was not credible. And this absolutely was not self-defense. So when you talk about how she complied with pretrial services and all that before trial, you have to look at it through that lens. She thought she was going to convince this jury, so she complied. She did everything she was supposed to do. She showed up to every court hearing she was supposed to come up to. She kept her ankle monitor on. She did all of that because her end goal was to put her case in front of a jury and win, and everything would be fine. Now Doug's out of the way, and now she has her child. That's the difference in this case, because now her last ditch effort.
The fact that she's arguing that she intentionally shot him just so that she could go through a trial, risk 20 or 30, I think the max was 30 on this, this was all part of a grand plan to get sole custody is laughable. It's laughable.
Effort has failed. And the jury has told her no. And she has now been sentenced to 20 years. Her incentive to comply with pretrial services with bond has been removed, completely removed. So the court cannot consider the severity of the sentence alone. I would agree that the case law says you cannot say, well, it's a 20-year sentence, so therefore she might flee. But you are absolutely allowed to consider that sentence in conjunction with the facts of this case. So let's look at the facts of the case. 20-year sentence, the earliest she could be released, roughly, my calculations are correct, with good behaviors after 17 years. So that would be in the year 2041. Her daughter is 6. Her daughter would be an adult by the time she got out. Her daughter would be 23 years old. And her entire goal throughout this entire case for years and years and years, and still today, is to be with her daughter. And she knows that if she loses this appeal, she has to turn herself in. She was willing to kill a human being to meet this goal. There is nothing to prevent her, if an appeal comes back not in her favor, from deciding she's not going to present herself. It's actually based on her prior behavior and the prior.
Help me understand. Is there anybody out there? I know there's people in the chat who think that Ashley Benefield is Amber Heard and didn't believe a word she said about domestic violence. But is there anybody, if you're on that side, who genuinely believes that this was part of a grand plan to get sole custody, to kill this man and then risk a trial, and then, you know, hoping that she was going to beat it? Yeah, she does have a constitutional right to a trial. Thank you, Heather, for pointing out the obvious, because a lot of people, including the prosecutor, don't seem to understand that. It's a big grand plan.
Motivation and the prior calculation, it's actually pretty likely that she would then absent herself from the jurisdiction and from the court to not serve her 20-year sentence. And that is what is different about this case and specific to this case, and the reason that this defendant should not get a bond. Thank you.
Thank you. Yes, sir, rebuttal. Before you start, earlier, you had talked about the Dooley case in Hillsborough.
Yes.
I thought you had talked about another case from the second DCA, but I now see in your packet there's a Cooley. So I think I misunderstood. At one point you were talking about Dooley, and another one you were talking about Cooley.
Cooley is a case from the second DCA where the defendant was convicted of second-degree murder with a firearm and was denied an appeal bond by the trial judge. The second DCA reversed that, and despite the state's argument to the contrary, it wasn't simply because the order wasn't sufficient. It was because the judge improperly considered as it on its own the length of the sentence as a basis to deny the bond. That's why we rely on Cooley, because it's not appropriate under the Youngins test to use that factor alone to deny bond.
I understand. I just want to clarify the
Yes.
record that there's been references to a Dooley, which is 2 trial court orders, and Cooley, which is a second DCA
Yes.
case. All right.
And as far as the state's effort to distinguish Dooley, I want the court to be clear. There was 2 bond orders granting appeal. So although the state's correct that the second time they've already shown that Mr. Dooley could be out on appeal, and it's a unique case because he lost his direct appeal, that I was retained and filed, and he was out on appeal bond while that appeal was pending. I didn't represent him on that appeal. Then I filed an ineffective assistance of appellate counsel under Rule 9141, and they granted us a new appeal. At that time, a second appeal bond was granted. But at the time of the first appeal bond that was granted by Judge Ashley Moody at the time, Mr. Dooley stood in the exact same position that Ms. Benefield stands in here today. It was after a trial where he claimed self-defense, and he was found guilty of manslaughter and was sentenced. And immediately after the sentencing, the judge granted an appeal bond. So the procedural posture is identical, other than the fact that 2 different judges thought it was appropriate to grant Mr. Dooley an appeal bond. The state spends a lot, and I want to note that Ms. Benefield voluntarily surrendered herself the same day the warrant was issued in this case. I'm sure that's reflected in the court file. So there's no difference in her behavior compared to Mr. Dooley's behavior. The state makes a lot of argument about the specific facts of this case. And if you look at the Torpelas case, 2024, 3rd DCA, they talk about the nature of the crime and the circumstances of the instant offense, and say that you really shouldn't consider the nature of the crime because it says, quote, if the nature of the crime alone were sufficient to deny bond, it would render the fact-finding and application of the Youngin factors irrelevant. State spends a long time talking about this detailed plan, and if you believe the state, this sounds like a first-degree murder case. You know what? The jury didn't find a first-degree murder. They weren't. Ms. Benefield wasn't charged with first-degree murder. She was charged with second-degree murder. The jury rejected that. They did not find depraved mind or malice. They found manslaughter. So, the state has a theory and speculates that this was a long plan and this was somehow premeditated. We're not allowed to second guess the jury's verdict. We accept the jury's verdict, and the court needs to rule based on the jury's verdict. It's not the state's opinion that there was a long plan. The jury's verdict is a manslaughter on that date. They have made no findings of fact concerning planning, premeditation, depraved mind. In fact, they rejected depraved mind and malice. This idea that she's been financed by other people, I didn't hear any evidence of that. I'm not aware of any evidence in the record of that. The state cites to, quote, record evidence. I'm not aware of a single piece of record evidence that supports the idea that she's going to flee, other than some speculation by the state that her last-ditch effort was to convince the jury, and she thought she was going to win at trial. I have a difficult time with that. I think most defendants that go to trial expect to win. That's why they're going to trial. So that's not unique to Ms. Benefield. It's not unique that she claims she's innocent. Thousands of trials happen in this courthouse where people go to trial and claim they're innocent. Some were acquitted, some were found guilty as charged, some were found guilty of lesser included offenses. The idea that she went to trial and thought, quote, she could convince the jury she acted in self-defense, number one, that's her right. Number two, again, it's not unique to Ms. Benefield. So I don't agree with the state that that's a legitimate basis to deny bond pending appeal. She has an extraordinary level of support in this community. She has strong issues for appeal. She has a long history of complying with the conditions of release. There's just simply no evidence in the record that she's going to flee except some speculation from the state. So I'd ask the court to grant the bond.
All right. Thank you all very much. I'll take it under advisement and issue a written order.
Thank you, Judge.
Thank you.
Oh, wow. He's not going to rule from the bench. He's not going to rule from the bench. I'm really surprised. Wow. Usually he does. And there goes Ashley. She was smiling in the beginning, but prayers up. And that is the end of that hearing. What say you? Thoughts, comments, questions, concerns? I think Eva Benefield was on Zoom. I think she was not going to be there today. Let's go to the chat. Penelope, thanks for becoming a new member. Yuri's math teacher again, thanks for gifting 5 memberships. On top, thank you for your super sticker. Wendy wanted to know if those women were here today. You mean the prosecutor stepsisters? Yeah, we saw one of them. She got to argue. The other one did not. Thank you, Clinton, for your support and for your 5. Lori concurs from Canada. Thanks, Lori, for your super chat. Wendy says another man who hates women, controlling creep. I think you were talking about Tommy when he got up and spoke, right? Everyone smash the like button while you're here. It helps the algorithm. Nina, why is he allowed to have an open speech, but her witnesses weren't? Because they were better controlled and questioned, and they probably could have. I mean, I don't think did he stop any of them from speaking? I'm sure the woman whose husband died had said everything that she wanted to say, I think. Thanks, Nina. Thanks, Mozzie, for loving being a cupcake. Alita Lee, thanks for hanging out for 2 months with me. Thanks for covering this and making it clear to the community on what is happening here in court. You're very welcome. WVU girl became a new member. Welcome. How long will it take before an appeal begins? They've already filed the notice of appeal. I think in New York, I know you have 6 months to perfect your appeal and to file briefs. So it could be at least that long before the papers are even filed. But they did file a notice of appeal, and so the process has been started. Annie Badani is praying for Ashley. Thank you so much for your 10. Cats Meow 420 says, so with elegance and style, caught a wave and took a ride. Enjoy. Please post Neil's address. Yes, I will. I'm going to put it in the show notes for anybody who would like to send Ashley a letter. He will make sure that she gets them based on my conversation with him the other day. I'm a little blown out by the light here, but I'll let you look at the view while I still talk to you. So hang on. See if we can, once I move out of frame, it'll focus better on the view. Look at that. Let's see if we can even get in tighter on it for you. A little humid here on Dave Matthews weekend, but it is a beautiful place to be. Windy out there today. Hopefully the sun will come out. I hope. Thank you, Chris, for becoming a new member. Appreciate you so very much. Don't start any rumors. Don't start any rumors. Something is so funny, Auntie Bev. That's what happened last year. Hi, Princess Salt. Dave is in Cancun this weekend. Dave and Tim on the beach, 3 nights on the beach. It's going to be amazing. Amazing. Can't wait. Thank you. Thank you. All right. So Ashley is doing very, very well, according to my conversation with Neil Taylor. Her faith is what's getting her through. And I think that we could see that through the testimony of the witnesses who came in as character witnesses, and the woman whose guest cottage she lived in that she knew from Bible class, and who's willing to be a custodian for her. She was a pistol, that woman. I love her. She was in the courtroom every single day. We saw her in the courtroom every single day, and we were wondering who she was, and now we know who she was. She's an Ashley supporter. Yeah, it was nice to see her a little bit happier, a little bit happy today, even for a little bit. That smile was amazing. I know, Loud Mouse. If I see her here, I'll say hello, but I don't know if she's here. I know she goes on tour. Emily Baker goes on tour with Dave Matthews a lot. I'm surprised I haven't run into her at a concert through the years, but we've never met in person. I don't even know that she knows who I am, but if I did see her here, I would I would go up and say hello. I would go up and say hello. I don't think that the judge is going to let her out on bond. I just don't see it. I think, yeah, that's what it is, right? No, I have not run into Emily, but all right, let's move over here. Let's move over here now so that we can talk. We can talk. Let's we got to fix this whole thing here. All right. But we're going to have to wait for a written decision because he will not be ruling from the bench like he normally does today, which is sad. That's blowing me out. All right, whatevs. A bunch of stuff dropped, you guys. I've been getting a lot of emails to cover the new Delphi motion. Let me know if you want to hear about that. I have some time to kill today. The sun's not really going to come out, so I have some time to kill. Delphi, and there is some cease and desist letters dropped on the Blake Lively thing. I don't know. There's so much vitriol in that case. I don't know if I want to cover it anymore. Oh, that's amazing. My daughter thought she was going to fail her math midterm, but now she thinks she did much better than she thought. So yay, yay, baby. Love you if you're watching. Delphi, you want Delphi? All right. You want to do Delphi? Let's do Delphi. Kylie says, this is so duck and disgusting. Why are they acting like she's a bad person? Because she wants her daughter. Isn't that what a good mom wants in her life? Yeah, I know. I don't know. This whole argument that it was some grand scheme, some grand plan, I'm just not buying it. I'm just not buying it. I feel like she felt desperate in that moment. She saw what he could do. She feared for her life. And, you know, why have a stand your ground law if you're not allowed to defend yourself? It's weird because it seems to apply to cases in which strangers kill other strangers when I think it was enacted for intimate partner violence. And so if we're not going to use it for its intended purpose, then what is the point of having that law in Florida, right? Yes, right. That's what they said. And their argument is like Ashley planned out everything for years. That was her grand scheme. Yeah, what an awesome plan, Kokomo, Indiana says. Not so much. No, not so much. All right, you guys are into Delphi? Yeah, I don't know. Listen, Karina, named after a Bob Dylan tune. Love it. Some of my kids are named after Grateful Dead songs. If you know, you know. There is more vitriol and hatred in the Blake Lively, Justin Baldoni coverage and the people that follow that coverage than in the Karen Reed case, if you can believe it. Like, it is the amount of hatred that people have for Blake Lively who don't even know Blake Lively personally. It just blows my mind. It blows my mind. None of us were there. None of us saw what happened. And so I don't know if I want to cover it because, you know what, I got enough hatred going on with the Karen Reed case and vitriol. I don't know if I need any more of that in my life. I don't know. I think I'm going to stick to the stuff that I feel passionate about, and I don't really feel passionate for either side on that. So I feel like it just brings so much hatred and vitriol and personal attacks against me and those other people. Yeah, I don't think I'm gonna. Yeah, Candace Owens is covering it now. Yeah, go on. I watched some of that. I actually watched some of that last night. Thank you, Mike, for gifting a membership. I appreciate you so very much. And Cast Meow has a son who's named after a Grateful Dead song. Love it, love it, love it. I know, it's just, you know what? It's never going to end. It ends with us. It's never going to end. I started covering it because I auditioned for that movie. I auditioned for that movie to play Blake Lively's mother. And so when all of this came up, I was like, oh, wow, this is crazy. I could have been in this movie. And the more I cover it, the more it's like people are comparing Blake Lively to Amber Heard, two different cases. One involved alleged domestic violence. This is an employment discrimination claim and sexual harassment claim. That's like apples and oranges. So I don't know. No, right. Nobody has come out to support Justin. There's somebody who's doing some really great coverage on it. If you're on depending on what side you're on. You know what we should cover though is Mariano Rivera. Have you seen that? The one of my Yankees, who apparently he has some kind of church and some kind of Bible study camp, and there was a girl who was SA'd there, and him and his wife allegedly covered it up. There's like a big lawsuit against Mariano and his Mariano. What did I say? Mariano Rivera, right? Hang on, I saved it in here. And that's kind of interesting to me. The Alexander brothers is interesting to me, but I don't think I need all of the hatred about the Blake and the Justin. I don't think it's like anything I need to do. Oh, look at that. Because of your interest in Blake Lively. I don't know. I think that there's really so much vitriol. Thanks, Anne. I don't know. I feel like if I was there, I could have put a stop to whatever was going on. I could have helped. I don't know. So I thought that was interesting, the Mariano stuff. There's a lot of other interesting stuff out there. And the thing is that something is going to drop on this Lively Baldoni case like every single day. And there's so much involvement that, so much hate. So much hate. Also, check your YouTube subscription. Make sure you didn't get unsubbed. I think there was an issue with YouTube. People were telling me they thought they were subbed, and then all of a sudden they weren't. So just check and see. Make sure you are. I'm going to need like an hour to go get some coffee and do some things, but make sure you set the notification bell so that when I come back, we'll read the Delphi papers anyway. And we can go over that. That's wild what's happening over there and the new evidence that has come out. Thank you. Thank you. Thank you, Live for Now. Mariano had some serious issues to deal with. Yeah, it's wild. I'd never seen his wife before. So when I saw that yesterday in the post, it's like, let me just read you the headline on that. Yankees icon Mariano Rivera and wife at center of bombshell child SA case. So that's interesting. There's a young girl who is alleging that when she was in the Refuge of Hope Church in New Rochelle, New York, she was SA'd by another girl. And then it happened again. I think this was in 2018. Then apparently it happened again. Well, let's see. First, she was abused at a summer internship in 2018 at the Ignite Life Center in Gainesville, Florida. Repeatedly. And then when the mother complained, Mariano and his wife went down there to address the concerns and says, oh, you know, don't worry. We'll look into it. Sounds very familiar from my work with the Catholic Church cases. And then it says that Mariano and his wife isolated the girl and then intimidated her to remain silent about her abuse to avoid causing trouble for the organizations, for this church organization. And then she went back to New York and continued to attend services at the Refuge of Hope. And then there was another incident of SA on this girl at Mariano Rivera's house in Rye, New York, during a barbecue for children of the Refuge of Hope Church with no parents invited to the event. So this is interesting. Right now it's a civil suit. And then there was another guy who also abused her. So this poor girl, but wild that Mariano and his wife would be in the middle of this. Right? Hello, Tom Gillis, golf instructor. Hello. Yeah, Ron Logan did confess to 2 people. You know who else did? Elvis Fields. He also confessed to 2 people. It's wild. All right. Make sure you have your notifications set. Make sure you're still subscribed because a lot of people got unsubbed for some weird reason. YouTube is glitchy. Make sure you hit like on the stream so that it'll help the algorithm. Share this out if you have anybody who you know who would be interested in watching it. I'm going to, when Neil Taylor sets up whatever fundraising fund for the legal defense appeals costs, I will post that as well. It's going to cost $100,000 for this appeal. And if she can't raise the money, then Ashley Benefield, then she's going to have a public defender. And the appellate attorney that they have is apparently one of the best in Florida. So I know how generous you guys are, and I know how many of you want to help Ashley, and maybe that's a way that you can help her. I'm going to put Neil's address in the show notes right now as soon as I finish so that you can write to Ashley if you'd like. I'm sure she would love your letters of support. Just pray for me that the sun's going to come out today in Cancun, and hopefully it will. But we'll come back and talk about Delphi. That'll be just maybe an hour or 2. Set the bell, set the notifications, keep checking back, and I'll set this up for like maybe noon or so. What time is it now? It's 10 a.m. Just keep your notifications set. I can't commit right now. I can't commit. I'm on vacation. All right. Stay cool, stay kind, stay classy. Thank the moderators for doing what they do so very, very well. Keeping it kind, keeping it classy. You guys are amazing. You totally rock. And I'm going to see you real soon.